7 members of the United States Supreme Court issued an emergency decision during the night. By the next morning, most people across the country had no idea it had happened. Consider that for a moment, not from the perspective of a Democrat, Republican, or independent voter, but simply as an American citizen. 7 of the 9 highest judicial authorities in the nation, the institution that serves as the final interpreter of constitutional law and the last barrier against government overreach, acted with such urgency that they did not wait until daylight. They released an emergency order, yet the story failed to dominate headlines. It did not become the center of public discussion. It was buried beneath celebrity controversies, manufactured political conflicts, and the daily distractions that constantly pull public attention away from decisions that genuinely reshape the nation. This was the Supreme Court's ruling concerning nationwide injunctions. Before examining the language of that decision, it is important to understand what occurred and why many observers view it as one of the most significant legal developments in generations. The term nationwide injunction sounds technical and procedural. It appears to be the sort of subject reserved for legal scholars, judges, and attorneys. That perception hides the practical reality. Once the mechanism is understood, many no longer see it merely as a legal procedure. They view it as a powerful tool that both political parties have repeatedly used. At its core, the process was straightforward. When a political side failed to achieve its objective through Congress, rather than accepting the legislative outcome and returning to voters with a new argument, attention often shifted to the courts. The question became simple. Which federal district court was most likely to deliver the desired result? The strategy focused on locating a favorable jurisdiction, identifying a judge whose judicial philosophy aligned with a preferred outcome, filing a lawsuit, and obtaining an injunction. In many instances, shortly after an executive action was announced or a state law was scheduled to take effect, a single federal district judge in a single courthouse could halt implementation across the entire nation. As a result, policy affecting approximately 330 million Americans could be frozen based on claims brought by a limited number of plaintiffs. Those plaintiffs might represent only their own circumstances, while other judges could interpret the same legal questions differently. Critics argued that such a system did not reflect the constitutional structure originally established by the nation's founders and did not resemble the democratic process they envisioned. What intensified concern was that many participants throughout the legal system recognized what was occurring. Legal academics discussing the issue in scholarly publications acknowledged the growing use of nationwide injunctions. Judges issuing those orders understood their broad reach. State attorneys general who sought such injunctions often criticized the practice when political opponents employed the same tactic. Yet the practice continued because it proved effective. Success in individual cases often outweighed efforts to reform the underlying system. The shortcut remained attractive because the alternative required the slower process of governance, coalition building, and legislative action. In 2026, the Supreme Court concluded that the situation had reached a critical point. 7 of the 9 justices agreed, despite ideological differences and political assumptions often promoted in public debate. They determined that limits were necessary. To understand why the court acted through an emergency order rather than its traditional process, it is necessary to examine developments that had unfolded in previous months. Several states filed lawsuits asserting that the federal government had exceeded constitutional limits. These challenges were not brought by fringe organizations. They came from sitting governors, attorneys general, state lawmakers, and other elected officials acting on behalf of state governments. Their argument was direct. They contended that federal agencies were issuing rules and directives through emergency powers and executive authority in ways that effectively altered state law without legislative approval, democratic consent, or meaningful public accountability. Those allegations raised substantial constitutional questions. According to the states, those concerns deserved careful judicial review. Instead, lower federal courts responded in many instances by issuing nationwide injunctions against the state measures themselves. States argued that federal authorities had exceeded constitutional boundaries, while federal courts used their own authority to stop state laws across the country before those laws were fully implemented. According to critics of the practice, these actions often occurred before courts thoroughly examined the underlying constitutional issues, and before cases received extensive evaluation on their merits. From that perspective, the judiciary was no longer acting solely as a check on executive power. It appeared to some observers to be operating in a way that protected executive actions, by preventing state governments from testing those actions through normal legal processes. The Supreme Court concluded that this was not an isolated incident involving a single judge. The justices viewed it as a recurring pattern. Lower courts had increasingly issued broad nationwide orders that extended far beyond the specific injuries claimed by the plaintiffs before them. The court had previously expressed concern. In Labrador v. Poe, limitations on the authority of lower courts had already been discussed. However, those earlier signals did not stop the practice. In certain jurisdictions, it appeared to continue and even expand. As a result, 7 justices took the extraordinary step of issuing an emergency order that altered how federal courts across the United States would approach nationwide injunctions. The language used in the ruling drew particular attention. Observers noted that portions of the decision were unusually direct and forceful. Rather than reading like routine legal language, some passages reflected concerns that certain members of the court had been expressing for years and were now prepared to state openly. Justice Neil Gorsuch authored a concurring opinion. He agreed with the majority decision, but chose to place his own legal reasoning into the official record. At the center of that opinion was a phrase that quickly became one of the most discussed legal statements of 2026. Gorsuch argued that when lower federal courts issue broad nationwide injunctions, they move beyond interpreting statutes. They move beyond applying legal principles. They move beyond performing the constitutional role assigned to the judiciary. Instead, he wrote, they begin acting as legislators. A sitting justice of the United States Supreme Court examined the conduct of federal district judges and stated for the permanent record that they were no longer operating as judges in those circumstances. According to his reasoning, they were functioning as lawmakers, not elected lawmakers, not officials accountable to voters, not individuals subject to election cycles or democratic oversight. Yet their decisions were shaping policy outcomes for the entire nation through lawsuits filed by relatively small groups of plaintiffs in individual jurisdictions. Gorsuch continued by emphasizing what he described as the traditional boundaries of equitable relief. Under that long-established principle, a court's remedy should match the actual harm suffered by the specific party appearing before that court. The logic, he explained, is straightforward. If an individual suffers harm, a judge can order that the injury stop. What a judge was never intended to do under the constitutional structure of the United States is take a lawsuit filed by one person and use it to prohibit conduct affecting approximately 330 million people who were never part of the case, never possessed legal standing in the matter, and may not share the same circumstances as the original plaintiff. According to that reasoning, such action is not the administration of justice. It becomes policymaking. And policymaking within the American constitutional framework belongs to branches of government that answer directly to citizens. Those institutions can be removed through elections. They face consequences when governance fails. Lifetime appointed judges do not face that same electoral accountability. Justice Sonia Sotomayor disagreed. Her dissent raised concerns that deserve careful consideration. Her argument focused on practical consequences and addressed a genuine problem. She warned that if injunctive relief protects only the plaintiffs who bring a lawsuit, the country could develop a fragmented legal environment. The same federal law might remain enforceable in 20 states while being blocked in 30 others. Rights and legal protections could vary depending on whether an individual happened to be a named party in a specific legal dispute. That could create unequal enforcement and inconsistent legal conditions for people living under the same federal government. Those concerns were acknowledged as legitimate. However, the majority concluded that maintaining broad nationwide injunctions would not eliminate inequality. Instead, it would simply shift the source of that inequality elsewhere. Under that view, national policy would increasingly be shaped not through elections or legislation, but through litigation strategy. Outcomes could depend on which side possessed stronger legal teams, greater financial resources, and the ability to file a case in the most favorable jurisdiction. The majority rejected that approach. They concluded that constitutional fidelity required a different path, even if short-term disruption followed. The practical implications begin with immigration. Immigration has been among the most heavily litigated and politically contested policy areas of the past decade. Nationwide injunctions repeatedly became the preferred tool for administrations and opponents alike. During Donald Trump's administration, travel ban policies were halted within days by district court judges issuing nationwide injunctions before the executive actions had undergone extensive litigation on their merits. During Joe Biden's administration, immigration enforcement priorities encountered similar nationwide blocks, this time originating from judges located in more conservative jurisdictions. The result was years of policy reversals, legal uncertainty, and hardship affecting people on multiple sides of the debate. The underlying constitutional questions remained serious, yet both political camps often found it more effective to seek favorable courts than to construct lasting legislative solutions capable of surviving democratic review. Under the framework established by the Supreme Court, that strategy becomes significantly more difficult. A state can no longer see its entire immigration enforcement system frozen by an order triggered by plaintiffs whose circumstances may have no direct connection to that state's legal situation. The next major area involves firearms policy. Regardless of personal views on gun regulation, the consequences are immediate. In recent years, numerous states enacted substantial gun safety measures reflecting the preferences of their own voters. These included expanded background check requirements, restrictions involving assault weapons, and red flag laws intended to keep firearms away from individuals experiencing documented mental health crises. Repeatedly, those state laws faced federal court challenges. Repeatedly, nationwide injunctions suspended them. The effect extended beyond the states directly involved in the lawsuits. Jurisdictions that had no role in the litigation could also be affected. That situation now changes. A state that adopts firearm legislation gains greater opportunity to enforce its laws, while legal challenges proceed through the normal judicial process. Courts retain authority to review those laws. That remains consistent with constitutional principles. What changes is that a single judge in a single courthouse can no longer independently erase policy decisions made by millions of voters living in another state. Election law represents another area heavily affected by the ruling. It exists where constitutional rights, partisan interests, and fundamental questions of voting procedures intersect. For years, nationwide injunctions played a major role in election-related disputes. Voter identification requirements, absentee voting regulations, redistricting cases, and early voting rules frequently became subjects of litigation. Both political sides often pursued broad nationwide blocks whenever court rulings appeared capable of influencing outcomes. The Supreme Court's decision makes it far more difficult for one lawsuit to suspend election procedures across the entire country. As a result, election policy disputes will increasingly return to the places where many believe they were always intended to be resolved: state legislatures, Congress, and ultimately the ballot box itself. Environmental policy also faces substantial consequences. Issues such as the Clean Power Plan, methane emission regulations, water quality standards, endangered species protections, and other environmental measures have at various times been halted through nationwide injunctions before courts fully considered the underlying legal questions. For those relying on federal courts to preserve standards that Congress has not enacted into law and state legislatures have not protected, that approach now becomes less dependable. The struggle shifts back toward lawmakers. That means greater focus on elections. That means greater emphasis on voters. At this stage, only part of the story has unfolded. The remaining chapter concerns the political reaction, because institutional responses often reveal whose interests were disrupted more clearly than official statements ever can. In the hours following the ruling, the White House and the Department of Justice released carefully controlled public responses. There was no strong celebration. There was no dramatic condemnation. There was no detailed explanation revealing where the executive branch stood on the constitutional issue the court had just resolved. Instead, officials stated that they were reviewing the order and evaluating its consequences. To many observers, that language reflected an institution absorbing a significant setback while avoiding any indication of how deeply it was affected. Within the Department of Justice, according to individuals familiar with internal operations and the practical impact of the ruling, one word surfaced repeatedly in private discussions: earthquake. Not a minor obstacle, not a procedural annoyance, an earthquake. Because the Supreme Court had not merely adjusted a technical legal procedure, it had altered a foundational mechanism that experienced litigators had relied upon for years. What occurred is more than a procedural adjustment. It represents a structural change in the way the federal government can rely on the judiciary to advance policy objectives. Attorneys representing the federal government understand the significance immediately. The implications extend across major regulatory initiatives that are currently underway. On the opposite side of the legal battle, state attorneys general moved quickly. Within hours after the ruling was released, attorneys general from several states submitted supplemental filings in ongoing litigation. Those filings cited the Supreme Court decision as direct support for arguments alleging federal overreach. The legal teams involved had anticipated a ruling of this nature. They had prepared in advance and acted as soon as the decision became public. For those who support constitutional limits on federal authority, the ruling provided a legal foundation they believed would finally receive a hearing in court. At the same time, the controversy surrounding nationwide injunctions reaches beyond party lines. Both political parties used the mechanism. Both sides defended it when it benefited them, and both sides criticized it when opponents employed the exact same strategy. This decision does not provide an advantage to one party over another. It does not permanently strengthen any single ideology. Instead, it changes the operating rules for everyone. For years, nationwide injunctions became an alternative route around the traditional process of governing. When outcomes produced through democratic institutions proved unpopular to one side, litigation often followed. When Democrats controlled the White House, Republican state attorneys general sought nationwide injunctions to halt progressive federal regulations. When Republicans occupied the White House, Democratic state attorneys general pursued identical forms of relief to block conservative federal policies. Each side defended the practice as constitutional when filing the cases themselves. Each side described it as judicial overreach when opponents relied upon the same legal tool. The Supreme Court's message applied equally to all participants. National policy cannot be created simply by locating a favorable judge in a favorable jurisdiction. If political leaders want authority to govern, they must prevail in elections. If they want policy changes, they must enact legislation. The responsibility returns to the difficult and often frustrating work that democratic self-government requires. The intensity of reactions following the ruling reveals how dependent many institutions had become on the shortcut that no longer exists. Looking ahead, it is important to understand what this decision does and does not accomplish. This was an emergency order. It was not the court's final comprehensive ruling on every legal issue involved. The underlying disputes now return to lower courts. Those courts must apply the narrower framework established by the Supreme Court when evaluating the cases before them. Federal judges throughout the country are now aware that broad nationwide injunctions lacking detailed and proportional justification may face rapid reversal. That reality introduces a level of accountability many observers believe has not existed in recent years. The federal government is expected to continue defending its position. Future test cases will likely argue that certain national interests are sufficiently compelling to justify broader remedies even under the revised standard. Differences among federal appellate courts are also expected. Some circuits may interpret the new framework one way, while others may adopt a different approach. Eventually, those disagreements could require the Supreme Court to return with a full merits decision addressing the issue in greater detail. For that reason, this ruling marks the beginning of a lengthy legal adjustment rather than the conclusion of the debate. Yet one thing appears unlikely to change. The Supreme Court has now stated publicly and formally, through a 7-2 majority that crossed ideological divisions, that nationwide injunctions should not function as instruments of political warfare. That declaration carries consequences throughout the legal system. It influences how attorneys counsel clients. It affects how advocacy groups design litigation strategies. It alters the way federal agencies assess risk when introducing new regulations. It changes how states evaluate potential legal exposure when adopting controversial laws. The strategic framework of American legal activism shifted almost immediately. Regardless of political preference, legal professionals across the country recognize that reality. There is also a broader implication. For many years, and according to some observers for decades, both political parties benefited from a federal judiciary that accumulated authority beyond what the Constitution originally envisioned. That development was not necessarily attributed to corruption. It was not necessarily the result of malicious intent. It persisted because it was useful. It simplified the pursuit of national policy goals. It allowed major outcomes to be achieved without enduring the difficult process of assembling lasting democratic majorities. Political actors could reshape policy without fully persuading the public. They could implement their preferred vision without winning every argument. They could influence governance without obtaining broad consent. The Supreme Court has now narrowed that path. 7 justices, representing both conservative and liberal traditions, and appointed by presidents from both major parties, examined the direction American democracy had taken and concluded that it should move closer to the constitutional structure originally established. That structure is more demanding. It requires greater effort from elected officials because the courthouse can no longer serve as an easy alternative to legislative action. Officials must return to the legislative process. It also demands more from citizens. When courts are less able to bypass political debate, the political process itself must function more effectively. A functioning democratic process depends on citizens who are informed, engaged, and capable of evaluating issues for themselves. That system is not always efficient. Its results often arrive more slowly. At various moments, it can frustrate people on every side of nearly every issue. Sometimes that frustration can be intense. Even so, supporters argue that it is a more honest system. They view it as more legitimate. They view it as more consistent with the democratic principle taught throughout American history. The government derives its authority from the consent of the governed rather than from legal tactics employed by the side with the strongest attorneys or the most favorable courtroom. The court can establish a constitutional boundary. Whether that boundary is respected is another matter entirely. That responsibility ultimately belongs elsewhere. It belongs to voters. It belongs to citizens. It belongs to Americans who choose whether self-government is worth the effort required to sustain it. The Supreme Court's 7-2 emergency ruling on nationwide injunctions stands as a significant moment in American legal and political history, not because it resolves every dispute, not because it ends every conflict, not because it guarantees that political leaders will immediately abandon alternative strategies and return to the hard work of governing. It matters because it compels a nation that has increasingly shifted its most difficult political questions into courtrooms to confront those questions in the places where many believe they were always intended to be addressed, in legislatures, in elections, and through direct democratic participation by citizens governing themselves. That is the full significance attributed to this decision. That is the development many believed would be overshadowed by the daily flow of headlines and distractions. If this analysis helped clarify the issue, share it with others interested in constitutional law, government, and public policy. Join the discussion and consider which policy area may experience the greatest impact from this ruling in the years ahead.